PVL3701 Property Law Study Unit 7 Co-Ownership. Number 1. Introduction. We define co-ownership in this study unit. A distinction is drawn between free co-ownership and bound co-ownership, and the consequences of this difference are briefly referred to. We discuss the position of co-owners in regard to the whole thing and in regard to their undivided share. The remedies available to co-owners are briefly discussed, as well as termination of co-ownership. Number 2, the definition. And then we have example 1. Q and R are co-owners of their farm Pulang, one undivided piece of land. They purchased the farm jointly before they were married. And then example number 2. X and his wife Y are married in community of property. They are therefore co-owners of the farm Waterford, one undivided piece of land in equal shares. And then the definition, co-ownership can be defined as the situation where two or more persons own the same thing and at the same time in undivided shares. It is important to note that it is the abstract concept of ownership that is divided, not the thing itself. Two forms of co-ownership can be distinguished, namely free co-ownership and bound co-ownership. In free co-ownership, the co-ownership is the only relationship between the co-owners. See the position of Q and R above in the example 1 above. Bound co-ownership exists where there is an underlying legal relationship between the co-owners which determines the basis of their co-ownership. For example, a marriage in community of property. See the position of X and Y in example 2. A partnership or a voluntary association. In all these cases, the underlying relationship will determine, for example, whether the co-owners can burden or alienate their shares, how the co-ownership can be terminated, and how the entitlements will be exercised by each co-owner. Number 2.1. The elements. Number 2.1.1. Ownership. Several persons cannot be separate owners of the same thing at the same time. No co-owner is a separate owner of the whole thing. Each co-owner owns the thing jointly in undivided shares together with the other co-owners. Number 2.1.2. Two or more persons. In co-ownership, there are always a number of legal subjects and various legal relationships are covered. Co-ownership occurs, for example, in the case of mixing of solids and mingling of fluids. Joint heirs, joint legatees, joint donees, and joint purchases. See the position of Q and R in example 1 above. Business partners and members of an unincorporated association are co-owners of the property owned by the partnership or association. In the case of a marriage in community of property, the husband and wife become co-owners of the common estate, each of them having an undivided share in the estate. When the marriage is dissolved by death or divorce, the common estate ceases to exist and is divided into two halves. Number 2.1.3. One thing in undivided shares. A co-owner is not the owner of the whole thing, nor is he or she the owner of a particular physical part of the thing, for no physical or corporal division of the thing has taken place. The thing which is jointly owned is not divided. It is the ownership which is divided by a conceptual or imaginary division. Thus, Q and R can be the co-owners of a fountain pen, a book, a house, a motor car, a wireless, a farm, etc. Q and R are co-owners in undivided shares of the thing concerned, regardless of whether the thing is a divisible or an indivisible thing. The undivided shares in the ownership of the co-owners may be equal. For example, Q has half and R has half, or unequal, for example, Q has 1/4 and R has 3/4. And then there's just an activity that you can study on your own time. Okay, number 3, rights and duties regarding the thing. Then there's an example based on the facts in Pretorius and Neft and Glass, 1908. Pretorius is the usufructuary of an undivided half of the farm Leeuwkloof, and also acts as the guardian of a minor son who owns a 1/8 undivided share in the farm, subject to her usufruct. Glass is the registered owner of the other undivided half of the farm. Apparently, with the consent of the other interested parties, certain of Pretorius and Glass's children quarried and burned lime in kilns which they had erected upon the farm, not far from the boundary of an adjoining property, Kalkjewel. They have they had made a road leading from this spot to the market, or at any rate improved an existing track so as to make it suitable for transport. Neft, a son-in-law of Glass's, having acquired rights to lime on the adjoining farm of Kalkjewel, began transporting his lime with the consent of Glass through the farm, Leeuwkloof, along the road used by those quarrying lime upon Leeuwkloof. Pretorius objected to this. Negotiations aimed at giving Neft a right of passage began, but they fell through. It is alleged that a contract was then concluded between Glass and Neft, by which Glass undertook to transport the lime to the market on behalf of Neft, and for that purpose used the road across Leeuwkloof. Number 3.1, whole thing. Please note that in this paragraph we deal with the whole thing owned by all the co-owners. Number 3.1.1, alienation or burdening. It should be borne in mind that the ownership is divided and not the thing. Therefore, to alienate by means of sale or donation, or burden by means of a pledge or mortgage, the thing as such, all the co-owners must consent to the alienation or burdening and cooperate in complying with the required formalities. In Bonnier 76 General Trading Proprietary Limited versus Caribbean Estates Proprietary Limited 2010, Van Eden remarked that the general rule is that a single co-owner cannot alienate or burden the whole thing of the property. If the common property is alienated or burdened with a real right, the consent of all the co-owners is required. Number 3.1.2, use. Every co-owner is entitled to use the thing reasonably and in proportion to his or her undivided share. Co-owners can jointly decide how to use the thing, for example, in terms of a use agreement. This agreement is, however, only binding on the parties to the agreement. Number 3.1.3, profit, income and fruits. The co-owners are entitled to share in the fruits, income or profit regarding the property in proportion to each co-owner's share. They may vary this by agreement, which agreement is binding only on the parties to it. Number 3.1.4, maintenance and expenses. The co-owners must contribute to the maintenance of and expenses regarding the thing in proportion to their shares. This is obligatory only in relation to necessary expenses for the preservation of the property. Okay, number 3.2, undivided share. And then there's an example. X and Y wish to divide their farm, Waterford, into units where X will use certain parts for sowing crops and Y will use the other parts for grazing purposes. Please note that this paragraph deals with the undivided shares of the different co-owners. Every free co-owner can make completely independent arrangements with regard to his or her own undivided share in the ownership of the thing. Every free co-owner may alienate, mortgage, burden with a personal servitude, rent or leave to his or her heirs the undivided share in the ownership, without the cooperation of the other free co-owners. In the case of bound co-ownership, this entitlement is restricted by the terms of the underlying legal relationship. For example, a marriage in community of property or a partnership. Every free co-owner can use the thing in proportion to his or her undivided share in the ownership, provided that the use is reasonable. A free co-owner cannot use the thing as though he or she were its sole owner. For example, one of the co-owners cannot give permission to a third person to use the common property without consulting the other co-owners. The profit which a free co-owner makes out of reasonable use, which is in proportion to his or her undivided share of the ownership of the thing, may be retained and need not be shared with the other co-owners. Number 3.3. Exclusive use of part of thing. Please note that in this paragraph we discuss the position regarding the exclusive use of a part of the thing. Only with the cooperation of all the co-owners may any steps be taken with regard to a specific portion of the thing. For example, by means of alienation, burdening, alteration, or renting of a specific portion of a farm. A co-owner cannot unilaterally appropriate to him or herself a portion of the thing, not even in proportion to his or her undivided share, without the cooperation of the other co-owners. The co-owners may also agree in proportionate use of a movable thing. For example, a tractor may be used by co-owners for different periods. And then there's a long activity which you can study on your own time. Number 4. Division of the thing. Number 4.1. Agreement to divide without termination of co-ownership. Free co-owners may agree with each other to divide the thing physically among themselves. They may do this in proportion to their undivided shares in the ownership of the thing or in any other proportion. They are free to make such physical division of the thing at will. Once all the co-owners have agreed, any co-owner may demand that the terms of the agreement be carried out. It must be pointed out, however, that such an agreement to divide in no way terminates the co-ownership in respect of the entire thing, since the agreement as to the division is only binding on the parties to it. Number 4.2. Agreement to divide and terminate of co-ownership. Co-ownership in respect of land will only be terminated when partition transfers are registered. A partition transfer is based on an agreement to terminate the co-ownership relationship and subdivide the land. Note that an informal partition agreement between co-owners of land is binding on parties to it. Every co-owner is at liberty to demand division of the thing at any time, unless he or she has bound himself by agreement with the other co-owners not to demand division for a certain period. Even in this case, the co-owner can still demand division. This act will merely constitute breach of contract and may lead to a claim for damages. And then there's another activity. Number 5. Remedies. Although the co-owners can regulate the use and control of the property by mutual agreement, co-owners occasionally exceed their entitlements or are not in agreement with each other. Depending on the circumstances, different remedies are then available. Number 5.1. Damages or division of profit. If a co-owner uses the thing unreasonably in relation to his or her share by using it for a purpose for which it was not intended or to an extent which is not in accordance with his or her share, the other co-owners can claim damages or division of profit. Number 5.2. Interdict. A co-owner can use an interdict to prohibit another co-owner from making unreasonable use of the property. All the requirements for an interdict must be proved. We will see this in Study Unit 6, paragraph 2.2. And then lastly, number 5.3, subdivision. If the co-owners decide to subdivide the property for any reason whatsoever, they must first try to reach an agreement on the form the subdivision will take. Only if they fail to reach such an agreement can they approach the court. When the co-owners disagree about the physical or corporal division of the thing, any co-owner may claim division by means of the actio communi dividendo. The applicant must show that he or she has already tried to obtain a division by means of an agreement with the other co-owners. Only when such an attempt has failed can a co-owner approach the court. The court has a wide discretion with regard to the division. The court usually endeavors to divide the property physically among the co-owners in accordance with the value of each co-owner's undivided share. The physical division of the thing is impossible because the thing is indivisible. As in the case of a painting or a building, the court may award the thing to one of the co-owners subject to payment of compensation to the other co-owners. It is also possible that the court may order that the thing be sold at a public auction and that the proceeds of the sale be divided among the co-owners in a particular way. When the action for the division of common property is instituted, division and adjustment may be claimed. In other words, apart from division of the thing, damages or a part of the profit made through unreasonable use of the thing may also be claimed. And then there's just a small activity that you can study on your own time. PVL3701 Property Law, Study Unit 8. Possession and holdership, nature of. Okay. Then we can just start here with example number 1. Q accidentally sinks a borehole on the farm belonging to X and Y and erects a windmill there. He was under the impression that the borehole had been sunk on his side of the boundary. And then example number 2. S leases 100 hectares of watervoer from his parents, X and Y, for grazing purposes. The lease contract is invalid and S is unaware of this until his attorney informs him of the invalidity. Example number 3. Based on the facts in S versus Briggs 1973, S opens his mail and finds pornographic material in it. He decides to take it to the police the next day on his way to work. In the meantime, he hides it high up in a cupboard in his bedroom so that his wife and children will not see it. That night, the police raid his house and discover the pornographic material. S is charged with the possession of pornographic material in terms of the Indecent or Obscene Pornographic Matter Act 37 of 1967, which prohibits possession of such material. Okay, number 1. Introduction. The concept possession is one of the most difficult concepts in the law of things. Authors writing on this branch of the law approach the problem differently. Broadly speaking, possession is a compound concept consisting of a physical situation and a mental state. When the term possession is used in the broad sense, it includes possession in the narrow sense. That is, unlawful possession, and holdership. Therefore, possession in the broad sense can be described as a real relationship between a legal subject and a thing, characterized by 2 elements. First, a physical element, the corpus, and secondly, a mental element, the animus. Depending on the content of the mental element, this real relationship is described as possession, which is always unlawful, or holdership, which can be lawful or unlawful. Physical control with the intention of an owner is possession, but physical control with the intention to derive a benefit is holdership. It is important to understand that possession in the narrow sense is only unlawful when it is distinguished from holdership. For example, if I am in possession of my car of which I am the owner, my possession is lawful. As you will see below, an example of a possessor in the narrow sense is a thief. A thief's control possession can never be lawful. It is more accurate to say that an owner controls his or her car. It is also one of the entitlements of ownership. However, it is not wrong to say that an owner possesses his or her car. Number 1.1. The physical element, corpus. The physical elements of possession and holdership refers to the physical or actual control exercised over the thing by the possessor or holder, in order for the person concerned to qualify as a possessor or holder. Without actual physical control, there is no relationship which has any significance for the law of things. However, the law has given the concept physical control a unique content and meaning. It is therefore always necessary to judge the existence of a physical control relationship according to the relevant legal criteria. This implies that in establishing the existence of physical control, it is necessary to consider the circumstances, the nature of the particular thing, the nature of the relationship, established customs prevailing in the particular context where similar relationships are concerned, and other similar considerations. Number 1.1.1 Direct physical control. In principle, physical control is a factual situation which is judged on the basis of physical criteria. A person has actual physical control of the pen in his or her hand or of the chair on which he or she is sitting. Such a person has direct physical control over the pen and the chair. In its narrowest sense, the term physical control can therefore be construed quite literally. Number 1.1.2 Indirect physical control. Since it is not always possible to exercise direct physical control over all things, it is necessary to construe physical control in a broader sense in certain circumstances, and specifically with reference to a particular kind of thing. Physical control in the broader sense applies, for example, to a chair which stands in a person's lounge, while the person is at work, or to a car locked up in the owner's garage. In these situations, the person has indirect physical control. Although the person is not in direct physical control of the thing, he or she may take up control at any time. Number 1.1.3 Acquisition of control. Here we have an example based on the facts in R versus Mafula, 1958. S and his friends go for a hunting weekend. S mortally wounds a kudu. The kudu manages to escape into dense bush. S gives up the search when darkness falls. On his way home from a party, Z, one of the farm laborers, stumble upon the wounded kudu. He fetches his friends and they slaughter the animal and take the meat to their respective homes. Z is accused of theft of the kudu. The requirement for physical control are applied more strictly where the acquisition of physical control is concerned than in the case of the continued existence or retention of control. Before a buyer can establish sufficient physical control for the purpose of effective delivery over the thing he or she has bought, the buyer will need to gain direct physical control of the thing. He or she can, however, then retain control over the thing by means of indirect control, for example, by locking it in his or her cupboard. Where actual physical control is required in order to establish control, such contact need not be comprehensive. A farmer cannot be expected to be present on all parts of his or her farm at the same time. Similarly, one need only sit on one chair to have control over a lounge suite as a whole. The cardinal question is whether the control of specific parts of the whole justifies the conclusion that the other parts fall within the sphere of the controller's activities. And then there's just an activity that you can study on your own time. Number 1.1.4 Personal exercise of control. And then there's an example. X and Y are co-owners of the farm Waterford. They purchase certain farm implements from C, the cooperative, in terms of a credit agreement. C reserves ownership of the farm implements. The farm implements consists of a plough, a tractor, a harvester, spades, hoes and picks. T steals the plough. The harvester is left with the farm workers on the northeastern corner of the farm, where it is required in autumn when the wheat is harvested. Z, a neighbor, borrows the tractor for a month to plow her own fields. When Z has finished plowing, she lends her rented plow to X and Y in return for the loan of the tractor. Physical control need not be exercised personally, but may be exercised by one person for and on behalf of another, as a representative or agent of the person who has control of the thing. An employee may control an employer's car on behalf of the employer. For example, if the employee uses the car in the course of his or her employment. Again, a doorman may control an umbrella for and on behalf of the owner, who has left it at the entrance to a building. In such cases, it is always very important to distinguish between control exercised for and on behalf of another and control exercised in one's own interests. The farm workers in the above example are exercising direct physical control on behalf of X and Y. Number 1.1.5, continuous control. And then we have two examples. Example 1 is based on the facts in Nienaber versus Stuckey, 1946. In September, S applies for restoration of control by means of the spoliation remedy against X and Y, who have locked the gate that gives them access to their farm, thereby effectively debarring S from access to his farming implements. S had left these on the farm after having harvested the crop in July. Since July, neither he nor his labourers have set foot on the land. X and Y argue that he has not been in control of the implements since July and that he is therefore not entitled to succeed with his application. Okay, and then example number 2, based on the facts in Scholes versus Pfeiffer, 1910. S builds a dairy for Z. Z refuses to pay S the agreed amount on the due date. In December, S locks the partially completed building to establish a builder's lien over the property. At the beginning of February the following year, Z takes control of the building. S applies to the court for restoration of his control by means of the spoliation remedy. Physical control does not necessarily imply that control of the thing must be maintained continuously. A farmer retains physical control over those parts of his farm that he seldom visits, and a person who leaves her car locked in a parking area while she does her shopping still has physical control over it. An important criterion in this regard is whether the controller is able to regain physical control at any time. Okay, the nature of the object under control and the surrounding circumstances, such as the type of use, play a role in determining if there is sufficient continuous control. If we continue the two cases that we discussed in the examples. And then there is just a small activity. And then number 1.1.6, degree of contact. The degree of actual contact required for physical control is generally greater for movable things than for immovables, simply because it is more difficult to maintain comprehensive physical control with an immovable thing. Okay, and then number 1.2, the mental element, animus. The mental element, also called the intention of the controller, is, like the physical element, a factual matter, since the presence or absence of a particular intention is established factually. In the absence of an intention, no legal relationship can be said to exist between the legal subject and the thing. The intention must be firmly established before the nature of the legal relationship can be determined. In this regard, the following requirements are relevant. First, the legal subject must be capable of forming a legally recognized intention. In other words, he or she must have the capacity to act. Specific legal principles govern this requirement in the module of Law of Persons. Secondly, the legal subject must be aware of the particular relationship between him or herself and the thing, in order for him or her to be able to form a specific intention with regard to it. And number 3, the legal subject must form and maintain a specific intention with regard to his or her control over the thing. It may be said that he or she should direct his or her will at the control of the thing. The specific intention formed by a legal subject with regard to his or her control of a specific thing determines the nature of the real relationship. Although different forms of intention were used in legal literature through the centuries, for the purposes of this module, we concentrate only on the intention of the owner, animus domini, and the intention to derive a benefit, animus extra commodum acquirendi. Okay, number 1.2.1, the intention of the owner, the animus domini. The intention of the owner means that the legal subject exercises control over a thing with the intention or disposition which would normally be found in the owner of the thing. The ownership intention entails that the person controlling the thing regards him or herself as the owner, and his conduct signifies to the world that he or she has assumed ownership. The necessary implication is that the controller will not recognize any other person's claim to ownership of the thing. Please note that the animus domini does not refer to the intention to be the owner or to become the owner. It is the intention of the owner, as if he or she is the owner. Although this intention and behavior can be exercised legally only by real owners, it is possible for a non-owner, that is, one who is not the owner in law, because he or she does not meet the legal requirements for establishing ownership to the thing, have the intention of an owner in certain circumstances. This intention may be found among three groups of persons. First, owners. Obviously, the legally recognized owner will regard and conduct him or herself as the owner of the thing. However, strictly speaking, the owner's intention regarding his or her control is irrelevant as far as the law of things is concerned, since the consequences of ownership that are legally ascribed to the owner are based not on his or her subjective intention, but on the recognition of his or her ownership according to the law. The real relationship of an owner to his thing is ownership. Secondly, bona fide possessors, or possessors in good faith. A bona fide possessor can be defined as a person who is not recognized as the owner of the thing, because he or she does not comply with the requirements for establishing ownership, but who has the intention of an owner on the incorrect assumption that he or she is in fact the owner. This assumption is also called the opinio domini. The person concerned is unaware of the fact that he or she does not meet all the requirements for ownership, or he or she has accidentally appropriated another's property, unaware that it is not his or her own. The best examples of bona fide possessors are: number 1, a person who concludes a contract of sale with a non-owner and who after delivery uses the thing assuming that he or she has become its owner. Number 2, a person who accidentally picks up another's pen, believing it to be his or her own, and who then uses it as his or her own property in that belief. And lastly, a person who encroaches on his or her neighbor's land, unaware that he or she is doing so. Although the bona fide possessor's control of the thing is unlawful, since he usurps a right that is not legally recognized, it still has certain legal consequences and is therefore significant for the law of things. Number 3, mala fide possessors, possessors in bad faith. A mala fide possessor can be defined as a person who is aware of the fact that he or she is not legally recognized as the owner of a thing, since he or she does not conform to the requirements for ownership, but who nevertheless has the intention of an owner. A thief is, of course, the best example. The mala fide possessor is characterized by the fact that he or she is unaware that he or she is not the owner of the thing. Although he or she need not know who the true owner is, or even whether there is an owner, he or she simply does not recognize another person's ownership of the thing. Although this relationship is unlawful, it nevertheless has legal consequences. It is important to bear in mind that the animus domini excludes the recognition of another person's ownership. A purchaser on credit who has agreed contractually that he or she will become the owner of the thing only when the final payment has been made does not have the animus domini, even though, in lay terms, he or she may regard himself as the owner in the interim. Before the final installment has been paid, the purchaser on credit intends to derive benefit from the thing and is not a possessor but a holder. Number 1.2.2. Intention to derive a benefit. Animus ex-re commodum acquarendi. A person who controls a thing with the intention of deriving a benefit does not regard him or herself as the owner of the thing, but simply intends to retain control over the thing and to keep controlling it to his or her own advantage. He or she does not consider him or herself the owner or conduct him or herself as such, and will always recognize the owner's ownership. Such a person usually exerts control over the thing on the basis of the owner's permission, or other valid legal grounds. The recognition of the owner's ownership is usually based on that permission or on the legal basis for control. This intention is found among two groups of persons. First, we have lawful holders. A lawful holder can be defined as a person who physically controls the thing with the owner's permission or on another legal basis, in order to derive some benefit from it. The holder does not regard him or herself as the owner, nor does he or she pretend to be the owner. He or she exercises control while recognizing and respecting the owner's ownership. The best examples of lawful holders are: number 1, tenants; secondly, borrowers; third, purchasers on credit who have not yet paid all the installments; and lastly, pledgees. These persons all base their control of the thing and their intention to derive a benefit from it on the owner's permission or on a legal ground, such as a contract incorporating the owner's permission. Number 2, unlawful holders. An unlawful holder can be defined as a person who does not regard or conduct him or herself as the owner, and who recognizes and respects the owner's ownership to the thing, but who physically controls it for the sake of the benefit he or she derives from it, without the owner's permission or other legal ground for his or her control. Two classes of unlawful holders can be distinguished here, namely bona fide and mala fide unlawful holders. The bona fide unlawful holder can be defined as a person who physically controls the thing unlawfully, but he or she is unaware of the fact, since he or she is under the incorrect impression that he or she has the necessary permission or legal ground to control it. An example would be that of a lessee who has unknowingly concluded an invalid lease contract. He or she therefore believes bona fide, but wrongly, that he or she is using the thing with the owner's consent, while such consent would not be recognized legally and therefore invalid, with the result that his or her control is unlawful. The mala fide unlawful holder can be defined as a person who knows that he or she does not have the owner's consent to control the thing, but he or she still exercises physical control over it for the sake of the benefit he or she can derive from it, not with the intention of an owner. An example would be that of a lessee who remains on the leased premises after the lease has expired. Possessors are holders are therefore distinguished on the basis of the specific content of the intention, with which each exercises physical control. Number 2, possession, fact or right. An age-old debate centers on the question whether possession is a fact or a right, more particularly a real right. In Roman Dutch law, there was a difference of opinion on whether or not possession is a real right. Roman law, as we have indicated above, did not refer to rights, but to actions. The question was always whether a person had an action in a specific situation. Certain classes of possessors were protected mostly in terms of possessory interdict. rights, and in one instance, even with an action. However, the classes of possessors that we have referred to above were only protected by means of possessory interdicts, and holders were not protected at all. Therefore, in a sense, we can say that the factual situation of physical control with the necessary intention, that is, possession as a fact, never gave rise to an action, and therefore possession was not a right. In modern law, however, physical control is protected to such an extent that even a mala fide possessor enjoys a strong measure of protection in terms of the spoliation remedy. The real relationship of possessors is therefore protected, although they do not have a right to the thing. Number 3. Eis possessionis and eis possedendi. Eis possessionis means the right of possession. Anyone who is in possession has the right of possession, because the law recognizes this real relationship and attaches certain consequences to the factual situation. Therefore, even the thief has the eis possessionis while the thing is in his or her possession. The right of possession entails that the real relationship may not be disturbed unlawfully. Eis possedendi means the legally recognized right to possess. The thief does not have this right to possess the stolen thing. A buyer of a thing has a right to possess before delivery has taken place, and once it has taken place, he or she has the right of possession. A holder, for example, a lessee, also has the legally recognized right to possess. Number 4. Possession and presumption of ownership. As long as a person is in control of a thing, that person has the right of possession. This does not mean that person has a right to possess. If, however, a third person wishes to claim the thing from the person in control, the third person must prove a right to possess it. The onus of proving a better title is on the person wishing to enforce it. Consequently, there is a rebuttable presumption of law that the person in control of the thing is also the owner of it, unless there is an admission by the controller of the other party's title as owner. An illustration of this principle can be found in the requirements for a successful reliance on the re vindicatio, where an owner who claims his or her thing from the person in control bears the onus of proving ownership. And then they have a very nice diagram setting out everything that we just discussed, along with a very extensive activity, which you can just study on your own time. PVL3701, Property Law, Study Unit 9, Possession and Holdership, Protection and Termination. Number 1. Introduction. In this section, we discuss the various remedies to protect possession and holdership. It is important to distinguish clearly between these remedies. Make sure that you know the purpose and definition of each remedy, as well as the requirements for and possible defenses against each remedy. The remedies are: first, a declaratory order; secondly, an interdict; thirdly, a spoliation remedy; fourth, a possessory action; fifth, condictio furtiva; number 6, Aquilian action, that is delictual action for damages; and number 7, enrichment action. Okay, number 2, remedies. Number 2.1, declaratory order. Under appropriate circumstances, a possessor or holder may apply for a declaratory order. For example, where there are two street vendors who both claim to have a right to use a stand on the street. Both street vendors can be either possessors or holders and must then apply for a declaratory order to determine who has the right to use the stand. Number 2.2, interdict. Here's an example based on the facts in Setlogelo versus Setlogelo 1914. During the apartheid regime, Francis Setlogelo occupied land which he inherited from his grandfather. Francis Setlogelo could not lawfully occupy or obtain transfer of the land as he was a black person and the land was situated in a white area. Isaac Setlogelo and Ephraim Setlogelo brothers and neighbors of Francis Setlogelo, started farming operations on that land. Francis Setlogelo applied for an interdict prohibiting Isaac Setlogelo and Ephraim Setlogelo from setting foot on the land. Isaac and Ephraim argued that Francis was not the registered owner of the land and that he therefore could not make use of the interdict. The purpose of this remedy is to protect the applicant's right to a thing or control over a thing from prejudice ensuing from the continual or imminent disturbance of his or her right. This is a summary court order ordering or prohibiting a specific act in order to prevent this prejudice from continuing or occurring. And then there's just a small activity that you can do on your own time. Okay, number 2.3, a spoliation remedy. And then there's two examples. Example number 1 is based on the facts in Nino Bonino versus De Lange 1906. Z leases a billiard room in Newtown from S. In terms of the lease agreement, Z is not allowed to serve alcohol on the premises or stay open after 12 at night. S and Z insert a term in the agreement entitling S to take control of the premises if Z contravenes any of the terms of the lease. Z serves alcohol on the premises to his friends and holds rowdy parties that went on until sunrise. The neighbors complain to S. S removes the locks from the building and fits new locks. He locks all entrances to the premises and effectively debars Z from using or entering the premises. Z applies for a spoliation order. Example number 2. V and W, farm workers in the employ of S, occupy and cultivate a portion of highlands. S has an argument with the farm workers and they refuse to work. S removes their furniture from their houses and burns it. He throws their clothing away. He also breaks down their houses and dumps the building material on a rubbish dump. And then you can just study diagram 11. Number 2.3.1, purpose. The spoliation remedy is aimed at the protection of the legal order in a unique way. Its purpose is to prevent self-help which may result in a breach of the peace. A spoliation order summarily undoes the consequences of such self-help, insofar as it has disturbed the existing relationship of control, without any reference to the lawfulness or otherwise of the pre-existing control which is to be restored. In other words, the court does not investigate the merits of the rights of the parties. Specific performance of a contractual right, that is, a personal right, does not form part of the purpose of the spoliation remedy. Number 2.3.2, the definition. A spoliation remedy is a summary remedy, usually issued upon urgent application aimed at restoring control of a thing to the applicant from whom it was taken by means of unlawful self-help, without investigating the merits of the original rights of the parties to control the thing. Number 2.3.3, the requirements. The requirements for a successful reliance on this remedy are the following. First, the applicant, spoliatus, the person whose control has been disturbed, must have enjoyed peaceful and undisturbed control of the thing. And secondly, the respondent, the spoliator, the person who disturbed the control of the spoliatus, must have disturbed the applicant's control in an unlawful manner. This remedy is used to restore an existing relationship of physical control summarily, without any investigation into the merits of the claims of the parties to the thing. The principle being that control must first be restored to the party despoiled. Spoliatus ante omnia restituendus est. The above emphasis on the purpose of the spoliation remedy, that is, to prevent persons from taking the law into their own hands by resorting to self-help, leads to the conclusion that the spoliation order, Amendement van Spoli, focuses not so much on the parties' rights to the thing as on the factual existence of control and on the protection of such control against self-help. It is not the applicant's right to the thing which is foremost, but the fact that the respondent unlawfully took the law into his or her own hands. The courts have stated on several occasions that the purpose of the remedy is the immediate restoration of the control which has been disturbed unlawfully, so that the control which originally prevailed may be restored legally. This argument is supported by the consideration that an applicant, spoliatus, who has succeeded with an application for a spoliation order has not thereby received the court's blessing on his or her control of the thing. The court does not condone the spoliatus's control or declare it lawful when restoration of control is summarily ordered. It merely condemns the unlawfulness of the self-help of the spoliator. It is self-evident that the act of spoliation must be unlawful, and this is generally presumed by the courts when a disturbance of control has taken place against the controller's wishes or without his or her knowledge. To deprive someone of control may be lawful and will then not constitute spoliation, if there is a valid and enforceable legal ground for such an act, for example, a court order. It is not sufficient for the spoliated to have a valid claim to control the thing. Such a claim must be enforced via the normal legal channels in order to obtain lawful control of a thing from another person is a valid legal ground, such as an order for attachment or ejectment is required. And then there's just an activity that you can study on your own time. And then number 2.3.4, defenses against spoliation remedy. And then there's two examples. Example 1, based on the facts in Recordsaw versus Northcliffe Keramics Proprietary Limited, 1997. A number of dwellings were erected on land belonging to Northcliffe Keramics, the respondent, without the latter's consent. The unauthorized dwellings were demolished by the respondent, and the materials with which certain of the dwellings had been constructed were burnt. Recordsaw, the applicant, applied for a spoliation order on behalf of the occupants who had been dispossessed of their dwellings by the respondent. And then example number 2, based on the facts in Iersche Trog CC versus Solra Trading CC 1997. I hope my pronunciation is correct there. Okay, the applicant brought an urgent application against both respondents, Soltra Trading CC as purchaser of the property, the first respondent, and the Demolition Corporation, the second respondent, for a spoliation order. What the applicant wanted was the restoration of a structure comprising a storeroom on first respondent's property in Fish Hook. The applicant alleged that it was in possession control of this room, which it had used as a storeroom until 8:30 in the morning on the 18th of April 1997. The background to this matter is that the first respondent had launched ejectment proceedings against the applicant on the 2nd of April 1997. First respondent had bought the premises in which applicant traded under the name of O'Hagan's Irish Pub and Grill. The applicant had apparently used the storeroom for the storage of empty crates, beer barrels, bottles, furniture, and umbrellas. At least part of the trouble which arose in this case was the result of the fact that the applicant had used this storeroom, apparently without paying for it, and either hoped or expected to be able to continue to do so. The ejectment proceedings, which were opposed by the applicant, were pending in the Simonstown Magistrates Court. On the 18th of April 1997, at 8:30, the applicant noticed that the employees of the second respondent had commenced knocking holes into the external walls of the storeroom. Attorneys on both sides were immediately enraged. Not much later, the applicant noticed that the workmen were completing demolition of the external walls to the storeroom. The applicant pointed out that he was unable to secure any of his property in the room in its present state. The following valid defences may be raised against the spoliation remedy. Number 1. The applicant did not have peaceful and undisturbed control at the time of spoliation. Bear in mind that there are different forms of physical control. Number 2. The respondent did not disturb the applicant's control. Number 3. The disturbance was not unlawful. Disturbance in terms of a court order, for example, is not unlawful. Number 4. The applicant waited too long in making his or her application. As a general principle, the applicant for a spoliation order should not wait longer than a year before the application is submitted. If the applicant has waited longer than a year, he or she should indicate the special circumstances which caused the delay. Number 5. It is impossible to restore control. The defense of impossibility requires further explanation, since the spoliation remedy is aimed at the immediate restoration of control to the position in which the applicant was before the spoliation took place. It goes without saying that this cannot be achieved if restoration is no longer available. However, in Fredericks versus Stellenbosch Divisional Council 1977, it was held that restoration may be ordered where it can be effected with materials of a similar nature to the materials which had been destroyed. In this case, the spoliator destroyed the materials on purpose so that restoration would become impossible. This approach was followed to a certain extent in Irschadroch versus Sultra Trading 1997. Where the court held that a spoliation order can be granted where the property has not been entirely destroyed. The court here granted an order for the rebuilding of a wall and a degree of substitution of the building materials. However, the court in Ricozzo versus Northcliffe Ceramics, Proprietary Limited, 1997, emphasized the inherent nature of the spoliation remedy, that is, the fact that it is aimed at restoration of control, and refused such an order. The court argued that if the materials had been destroyed, restoration was impossible, and the spoliation remedy was not the applicable one. In such circumstances, a delictual claim for damages is the appropriate remedy. And then there's just an activity that you can study on your own time. Number 4, a possessory action. And then the example they give us here is S, the son of X and Y, leases a portion of his parents' farm. When his father's farm implements are stolen, he gives some of his rented equipment to his father, X, to use. Father and son have an argument. In his anger, X destroys his son's rented equipment. Where a person in control loses control under circumstances where the spoliation remedy does not apply, such a person may still use the possessory action to recover control or even to claim damages resulting from the loss of control, or may even claim both the restoration of control and damages. The purpose of the possessory action is to claim the thing or its value from anyone with a weaker right to control the thing. And then there's just another activity. Number 2.5, Condictio furtiva. The purpose and requirements of this action are the same as for the situation where ownership is protected by means of this remedy. In the Clifford case, the plaintiff was indeed not the owner of the car, but a lawful holder. And then there's just another activity. And then number 2.6, Aquilian action. And then we have two examples. Example number 1. Employees from the local authority, without notice and without the proper authority, start to break up the dam on S's farm and dig trenches across his land. This is part of an extensive sewerage system which also crosses S's farm. While working on the farm, they use some of S's farm implements, which S bought on credit from the cooperative with reservation of ownership, causing such wear that S can no longer use the implements. Example number 2. S, the son of X and Y, leases a portion of his parents' farm. When his father's farm implements are stolen, S gives some of his rented equipment to his father, X, to use. Father and son have an argument. In his anger, X destroys the rented equipment which his son S had lent to him. The purpose of and requirements for this action are the same as for the situation where ownership is protected by means of this remedy. Okay, for a full discussion of Inquilian liability, see the module on the law of delict. Okay, note that the Inquilian action is a delictual remedy originating from an obligation created in terms of a delict, by means of which the owner of a thing, for the purpose of the law of things, may recover damages from someone who has culpably and unlawfully damaged it. In principle, it is clearly the owner of the thing whose estate is impaired by damage to the thing, which forms part of the estate. The owner is therefore, in principle, the only one who may use the delictual remedy. However, there are cases in which another person may suffer patrimonial loss as a result of damage to a thing, of which he or she is not the owner, and the question then arises whether such a person should also be protected by the delictual remedy. This question becomes relevant in cases in which a non-owner has an interest in the particular thing, to the extent that damage to the thing will impair his or her estate as well. Someone who buys a car on credit with reservation of ownership, for example, and who is therefore a lawful holder, may have paid a large part of the price when the car is damaged by a third person. The owner-seller may decide not to sue for damages since the car has almost been paid for in full. The buyer's predicament is that although he or she is not the owner, he or she is prejudiced directly by the damage to the car. In a case such as this, it may be necessary to put the delictual remedy at the buyer's disposal, in spite of the fact that he or she is not the owner, since his or her estate is directly affected by the damage. In principle, bearing in mind the requirements for the delictual remedy, one may only recover damages on the basis of the Aquilian action for unlawful infringement of a patrimonial interest. That is, if the plaintiff has a lawful claim to the thing or to its control. This implies that the delictual action is available only to those who can prove a lawful patrimonial interest in the thing. Therefore, this remedy is at the disposal only of the owner or the lawful holder who can prove the elements of the Aquilian action. The debate about the possibility of and the theoretical justification for the so-called extension of the delictual action to holders is based on the theoretical point of departure that patrimonial damage is damage to the thing of an owner, since the thing forms part of the owner's estate. On the basis of this argument, but with consideration for the fact that modern law recognizes that other persons besides the owner may have a patrimonial interest in the thing or in control of the thing, the delictual remedy has been conferred on the following non-owners. First, bona fide possessors, and secondly, lawful holders. For example, buyers in terms of a deed of sale, where the risk has passed to the buyer but ownership has not been passed. And then there's just an activity that you can study. And then number 2.7, enrichment action. In terms of an enrichment action, a plaintiff can recover compensation for unjustified enrichment from the owner of the improved thing. This action is based on the principle that unjustified enrichment should be compensated. Unjustified enrichment takes place when one person improves another person's thing without legal cause, for example, a contract, so that the owner of the thing is enriched at the expense of the improver. The enrichment action is specifically aimed at cases where there is no legal cause for the improvements and therefore no legal action available to the plaintiff. An enrichment action can be instituted for expenses incurred to improve the thing or expenses incurred to salvage the thing. Expenses or improvements are divided into three main categories. First, essential necessary expenses or improvements. Impensae necessariae, which are expenses essential for the preservation of the thing. For example, installing a new crankshaft in a motor vehicle that is not in working condition because of a broken crankshaft. Number 2. Useful expenses or improvements. Impensae utilis, which are expenses that, while not essential for the preservation of the thing, nevertheless raise its market value. For example, installing a device that improves the petrol consumption of a motor vehicle. And lastly, number 3, luxurious expenses or improvements. Impensae volupturiae, which are expenses that are neither essential for the preservation of the thing nor increases its market value, but merely gratify the caprice or fancy of a particular individual. For example, the replacement of a motor vehicle's upholstery with leather upholstery. An enrichment claim can only be instituted for essential, that is, necessary expenses or improvements and useful expenses or improvements, and not for luxurious expenses or improvements. This action is available to possessors and holders, lawful or unlawful. A successful plaintiff will be entitled to compensate for the amount by which the owner is enriched, or for the amount by which the plaintiff is impoverished, whichever is the lesser of the two. If it is feasible and will not cause damage to the property, the plaintiff may be allowed to remove the improvements to the thing. Ace tulendi. Okay, and then we just briefly discuss termination of possession and holdership. Here we have an example. X and Y are co-owners of the farm Watervoort. They purchased certain farm implements from C, the cooperative, in terms of a credit agreement. C reserves ownership of the farm implements until the final installment has been paid. The farm implements consists of a plough, a tractor, a harvester, spades, hoes, and picks. Z, a neighbor, borrows the tractor for a month to plough her own lands. T steals the plough and gives it to his son, T Jr., to use. After some intensive searching for the plough, X and Y decide to get a new one because they cannot do without a plough on the farm. Since they are buying a new plough, they decide to get a new harvester and allow the neighbor Z to use the old one. T Jr. can no longer hide the tractor from the police and he sets fire to it, destroying it completely. Y dies. Okay. In this section, the methods by means of which possession and holdership are terminated are discussed. These are similar to the methods of termination of ownership discussed in Study Unit 6. Since both the physical and mental elements are required for possession and holdership, these real relationships are terminated once one of the elements is no longer present. The chief methods of termination of possession and holdership are: firstly, death of possessor or holder; secondly, destruction of the thing; and lastly, number 3, termination of the legal relationship through either loss of the physical thing or loss of the mental element. The intention of an owner in the case of possession and intention to derive a benefit in case of holdership. And then there's just a small activity which you can study on your own time.